Hello everybody, it's your immigration attorney, Luis Ruiz, here with you today to talk to you about adjusting your status through your U.S. citizen son or daughter. Now, in order for your child to petition for you, they must be U.S. citizens and they must be at least 21 years of age. Now, I get a lot of people who come into my office and think that just because their child has turned 21 years of age and they're U.S. citizen, that they now are able to obtain permanent residence in the United States. That's just simply not true. Now, a child can petition for a parent as long as they're U.S. citizens and they're over the age of 21 years of age. However, the parent must still independently qualify to obtain lawful permanent resident status. And that means that you have no criminal history or not any that will eliminate your eligibility, and that you must be able to have to do the process either internally in the United States or externally in your home country. Now, the problem that I see at the office is this, that somebody comes into the office and they say, okay, my son's 21 years of age, let's go ahead and get this process started. And I say, okay, well, tell me how you entered the United States. In order to qualify to adjust inside the States, you must have entered lawfully, or you must have a petition filed on your behalf before April 30th of 2001. So somebody comes in and they say, well, they didn't enter lawfully and they don't have an approved petition before that date, then I have to give the bad news and say, well, you don't qualify to adjust your status in the United States. Let's see if we can send you to your home country to do it out there. Now, the problem with that is that when you leave the United States, depending on how long you've been unlawfully present inside the United States, then you will either have a 3 or 10-year bar. That means you won't be able to come back for 3 or 10 years, depending on how much time you were present unlawfully. So, in order to be able to feel comfortable enough to send somebody outside of the country, I only do so when we have a waiver that we're able to get done before they leave. So before they leave, we'll do a waiver. And in order to qualify for the waiver, you must have a spouse or parent who is a U.S. citizen or permanent resident who's going to suffer extreme hardship if you're gone for 10 years or if they have to go with you for 10 years or 3 years, depending on your bar. Now, so if somebody comes in and they don't qualify to adjust here and they don't have a spouse or a parent who's a U.S. citizen or permanent resident, then I don't feel comfortable sending you outside of your home country, and most clients don't want to leave the United States and knowing that they're going to have a 3 or 10-year bar and they won't be able to qualify for a waiver to get back into the United States. So I am always having to give out the bad news that there's sometimes no way to adjust your status. Even though your son, who's 21 years of age and a U.S. citizen, can petition for you, that doesn't mean that you are going to be able to obtain permanent resident status, because you still have to determine whether you apply here in the United States or if you have to go to your home country. And if you do have to go to your home country, whether you qualify for a waiver to return immediately. Oftentimes, people do not. What we do see sometimes is that one parent entered lawfully, the other one didn't. So what we'll do is that first, we legalize the parent who entered lawfully because they qualify to do it in the United States. And then, when that parent has a permanent resident status, then we'll do the other parent, the one who did not enter lawfully, because even though they don't qualify to adjust in the United States because they didn't enter lawfully, they now have a spouse who is a permanent resident, and we'll be able to do a waiver before they leave. So they'll leave and come right back into the United States if there are no other issues or complications. So just because your son is 21 years of age or your daughter is 21 years of age and they are a U.S. citizen does not mean that you will get permanent resident status. You still have to independently qualify, and sadly there are a lot of families and a lot of people who come to me and who I have to give the bad news that there will not be there's nothing I can do for them because they don't have a way to adjust in the United States, and they don't have a way to get a waiver to return back to the United States if they leave. So I won't be able to do anything for them unless they're willing to wait the 3 or 10 years outside of the United States, which most people are not. So if you have any more questions, or if you want to see if you qualify, or you want to get started with your process to adjust your status and obtain legal residence based on your son or daughter who is over the age of 21 and a U.S. citizen, then give us a call. My office number is 832-390-4664. We're here to help. We'll fight for your rights, and we'll make sure that if you qualify, that you are able to obtain your permanent resident status. You can find us online. My website is www.luisruizlaw.com, or my social media sites are Luis Ruiz Law. You can find us on Facebook, Instagram, Twitter, and YouTube. Thank you.